Good afternoon and welcome to Greenfield Solicitors YouTube video with myself, Rahila Hussain, Principal Solicitor of Greenfield Solicitors. I am an expert in immigration and human rights law and qualified as a solicitor in July 2003. I have now over 14 years of immigration law experience and I would like to share this information with the viewers watching us. I should point out that the information I provide on today's video is just general information and it should not be relied upon in any way for legal advice. If you would like legal advice on your immigration matter, please do contact our friendly immigration team to book a consultation for advice on 0208 884 1166. To tell you a little bit more about Greenfield Solicitors, we were established in 2008 and we specialise only in immigration, human rights law and nationality law. This is the only field of law that this firm undertakes, and because of that we are specialists and well regarded in this area of law. Our aim is to help our clients to obtain either leave to remain or entry to the UK as per their requirements. I'd like to touch upon a major change that occurred in April 2017, which is with regards to the new Home Office fees which were enacted in this month. So the most common applications that we undertake at Greenfield Solicitors are usually indefinite leave to remain applications or further leave to remain applications and also nationality applications. You can actually find a full fees list on the Home Office website and that will tell you the current Home Office fees along with the fees being specified in the actual application form that you may wish to use when making an application to the Home Office. And also you may wish to ask a legal advisor, if you have one, to ensure that when you submit an application, you submit the correct fee. It is extremely important to ensure that you apply for the correct visa using the correct fee, otherwise the Home Office could reject the application as being invalid. Now, for applications made within the UK, which are submitted to the Home Office whilst the migrant is in the UK, currently the fees for indefinite leave to remain for a main applicant are now £2,297. This is an increase of £422 prior to April 2017. Furthermore, leave to remain applications, often used in discretionary leave to remain applications or further leave to remain applications, are now £993. Previously, the Home Office fee prior to April 2017 was £811, so the Home Office has increased the previous and current fee by £182 for this kind of application. In addition, naturalisation has increased only slightly. It was £1,236 previously and now it's £1,282, so that's a slight rise of £46. The Life in the UK test and administrative review, I'm pleased to inform you that there have been no changes on the fees. These remain the same as previous, with Life in the UK test being £50 and administrative reviews continuing to be £80. For applications made outside of the UK, so for entry clearance applications submitted at the British High Commission or British Embassies abroad, for settlement applications for an individual, the current fees are £1,464, and for settlement applications where there are other dependent relatives, such as if you're bringing in a mother, a father or uncle, aunt, the current Home Office or British High Commission fee is currently £3,250, which is significantly higher than what they were charging pre-April 2017. The fee then was £2,676. Again, if you would like to find out our current Home Office fees, please do check on the Home Office website. Also, I would like to point out that there is something called an immigration health surcharge, which my regular viewers will know I've touched upon in previous videos. So you should be aware that when you apply for a visa, you will have to pay both a Home Office or British High Commission fee along with an immigration health surcharge. The immigration health surcharge is usually a few £100s and the amount will be depending on which type of visa you are applying for. So again, please do ensure that you do your research because it's important that you pay the correct amount for an IHS fee. Now, another subject I would like to touch upon which I think is quite interesting and often comes up, and something that the Home Office is keen to explore in more details with applications submitted, is now that there are general grounds for refusal when a migrant owes a debt to the NHS. So on the 6th of February 2017, the government announced that new regulations will come into force as of April 2017, which is current, and these changes are requiring all hospitals in the UK to check whether patients are eligible for free NHS treatment, and if they are not eligible for free NHS treatment, then they will have to be charged by the hospital for upfront fees for non-urgent planned care, such as operations and so forth. The reason the government has introduced this is it is part of their programme to recover the cost of health treatments provided to patients who are not ordinarily resident in the UK, and the government aims to recover the sum of about £500 million a year from overseas visitors who are not eligible to use the NHS for the tax year 2017 to 2018. Reference is made to paragraph 320 subsection 9 of the Immigration Rules, Appendix FM, which says the following, that where an entry clearance application is made, so at a British High Commission or British Embassy, such an application should normally be refused where one or more relevant NHS bodies has notified the Secretary of State that the person seeking entry or leave to enter the UK has failed to pay a charge or charges with a total value of at least £500 in accordance with the relevant NHS regulations on charges to overseas visitors. Similarly, an application for leave to remain and variation for leave to enter or remain in the UK for migrants who are already in the UK and seeking to make an application to the Home Office should also be refused where there is a debt of £500 or under, and this can be found under paragraph 322 subsection 12 of part 9 of the Immigration Rules. This can affect many migrants, therefore within the UK, and those who are wishing to enter the UK if there is a debt owing from previous NHS care obtained and where they have debts that are at least £500. So, who is ordinarily resident in the UK and therefore can benefit from free NHS care, and who is not considered as being somebody who's eligible for free NHS care and must pay? Well, there is no statutory definition, but a person will usually be ordinarily resident in the UK if they are living in the UK lawfully and they are settled as part of the regular order of their life for the time being, whether it is short or long duration. So for example, people here who are on visas where they are living here and they're residing here for the long term. However, a distinction should be made that where people are not eligible for free NHS care. So the Department of Health's guidance obliges patients to pay for charges to the NHS where, for example, they are in the UK without right to remain. For example, an illegal entrant or overstayer would be eligible to pay an NHS fee, or those on visitors' visas, as they are just simply visiting the UK and therefore they are not automatically entitled to free NHS care, or those on fiancé or proposed civil partner visas, because these are usually temporary visas that need to be changed into settlement visas, but whilst once is on a fiancé or proposed civil partner visa, they would not be eligible for free NHS care. So the question is then, who is eligible for free NHS care? Generally speaking, this is not an exhaustive list. Those would be in the UK with valid visas of more than 6 months. They would be eligible for free NHS care. Asylum seekers and refugees, prisoners and immigration detainees, EA nationals and their family members, and nationals of countries with whom the UK has reciprocal health agreements, and these can be found on the Home Office website. So it's very important to note and find out whether you are eligible for NHS care for free, or if previously you have not paid for NHS care that you subsequently find out that you are eligible for. This could have a serious effect on any future immigration application made. So people who have paid the immigration health surcharge as part of their application, they are entitled to use the NHS for the duration of their visa. So they have already paid for the privilege of using the NHS when they actually pay an immigration health surcharge with their application, and assuming their immigration application is approved and they're granted further leave to remain or enter in the UK, then they certainly will be entitled to use the NHS during the period that they have valid leave. So according to reports, what we have also found out is that it's important to note that treatment by GPs is sometimes provided free of charge to migrants, be they here lawfully or unlawfully. And even in some circumstances, one can obtain free NHS treatment even if they are not eligible, if, for example, they require urgent treatment at an A&E department, where it is required to do diagnosis and treatment for specified infectious diseases such as TB, malaria, yellow fever, where there is diagnosis and treatment for sexually transmitted infections, most commonly HIV, for family planning services, and treatment required for a physical or mental condition caused by torture, female genital mutilation, domestic violence or sexual violence. So this is usually available to people who are in the UK who undertake, or need urgent treatment for public policy or for their own reasons. So regardless of their immigration status, they are eligible for free NHS treatment. It should be noted that the NHS fees, if not paid by a migrant, the Home Office can look into whether they can exercise discretion to still grant an application or visa to a migrant who hasn't settled that debt, but it is at their discretion. Now in practice what we usually find, so applications are done smoothly, and while that difficulty for applicants applying for leave to remain or enter, do try and settle a debt owing to the NHS. If you have a clear record, if there are clearly no fees outstanding, then this will make it significantly easier in terms of obtaining leave to remain under one of the required immigration criteria. So what I'd like to do is give you an example. So here's an example. Sandra applies for leave to enter the UK with her 2 children. Sandra gives birth to her 2 children while in the UK while she has no legal status, so she's overstayed her visa. The NHS did not inform Sandra that she had to pay for the costs of her pregnancy and childbirth. However, the Home Office have subsequently contacted the hospital as Sandra submitted an application to the immigration authorities requesting regularisation of legal status, and the NHS will have informed the Home Office that actually Sandra has had children and there has been a cost for that service as she had children while she was unlawfully in the UK. Therefore, the Home Office refuses Sandra's immigration application as she owes at least more than £500 for the cost of her 2 pregnancies and childbirths. Therefore, Sandra decides to pay the hospital the outstanding debt and settle it in full for the cost of the births and any outstanding debts owing to them. And she subsequently submits a further application to the Home Office for consideration, requesting regularisation of legal status, and this is then granted by the Home Office because she satisfies the relevant criteria and because there is no NHS debt showing. So what's important to also note is outstanding debts to the sum of £1,000 or more incurred between the 1st of November 2011 and the 5th of April 2016, which have been outstanding for more than 3 months, well, the NHS has an obligation to notify the Home Office of this when a migrant has made an immigration application. In addition, the NHS has an obligation to also notify the Home Office of outstanding debts of £500 or more incurred after 6th of April 2016, which have been outstanding for more than 2 months. So please do be aware that when you actually do make an immigration application and there are NHS debts, the NHS is obliged to inform the Home Office, upon the Home Office obviously contacting them, of the debts, and this can be a serious ground for refusal until the migrant actually pays back the immigration health surcharge, pays back, I beg your pardon, the NHS fees due for the debt. It's also important for a migrant to note down any details of when they obtained hospital or medical treatment, because in the immigration application form it may actually ask, where did you get this treatment? What date did you get the treatment? What did you get the treatment for? And it's really important to try and provide accurate and truthful information in the immigration application so as to ensure that the Home Office are satisfied that the migrant has been fully open and given full disclosure. Because under the immigration rules, if the Home Office suspect or have reasonable belief to believe that the migrant is being deceitful and not providing the information, and they have subsequently found out that the migrant did get NHS care or treatment and they did not disclose that in their application form, then the Home Office could say, well, you've deceived us, you've sought to deceive us for non-disclosure, we're going to refuse your application, which is quite serious because there are immigration rules that could be used against the migrant to prevent them from regularising their legal status in the near future. Again, if there's any doubt on this, please do obtain legal advice, as we would suggest that wherever there is any doubt or uncertainty in an immigration case, you should get the best legal advice that you can. So the next subject I'd now like to touch upon is, it's a well-regarded section, and it's Section 3C and Section 3D of the immigration rules. Now what Section 3C actually is where, for example, an applicant has, let's have an example scenario here. They have visa, whichever category, and let's pretend it expires on the 1st of December. Then any time before the 1st of December, if they decide, right, their immigration rules or their circumstances need a change in the immigration application, then they can go ahead and make this to the Home Office. Now usually you submit an application 28 days before the visa expires, or at the time that a material change happens, because you don't want the Home Office not to know your current circumstances. If you submit the application before the visa expires, under Section 3C of the Immigration Act 1971, your leave will continue in the UK. However, there have been changes that have been recently made in 2017, where the Home Office now have powers to say, look, where you have submitted an application to us and it's not valid, for example, you submitted an application form, you provided the wrong fee to us, then they have 10 days to notify the applicant. I beg your pardon, they have an opportunity to notify the applicant to say, look, you've provided the wrong fee and we are giving you, the Home Office, 10 days to provide the correct fee to us. And if the applicant does not respond within that 10-day period, they might apply after 12 days, then what will happen is the Home Office will reject that application as invalid, and that person's leave under extant leave under Section 3C will end and they will not be lawfully here. So the Home Office has become significantly stricter when applying Section 3C leave. I've got a couple of examples here. So let's talk about leave expires on the 1st of November. A valid application is made on the 20th of November to extend leave. In this example, leave is extended by Section 3C because a valid application has been made while the person has leave. Now, here's another example. Leave expires on the 21st of August. An application is made on the 21st of August by the migrant to extend leave. The application is invalid as mandatory documents are missing. The applicant is given the opportunity to provide missing documents. The missing documents are not provided, and the application is rejected as invalid on the 30th of August. The person will have therefore been without leave from the 22nd of August, and the leave having expired on 21st of March. Now, the final thing that I'd like to touch upon is that as of the 1st of May 2017, the Home Office has increased the English language requirement for the family route, and that is now being increased to level A2, which was previously level A1. So that's level A2 of the English language requirement has been placed in force on the 1st of May 2017. I hope these updates have been helpful to you, and I thank you for watching myself, Rahila Hussain, the Principal of Greenfield Solicitors. Please learn more about us at www.greenfieldsolicitors.com. Thank you.